You just received a disciplinary action, a written warning, a final warning, a suspension, and you believe it is wrong, unfair, inaccurate, possibly retaliatory. Most employees sign it because they don't know they have options. You have options. Here is how to use them. This is what the talent. Before you do anything, understand exactly what type of disciplinary action this is. Written warning is a first formal documentation and usually part of a progressive discipline policy. Final warning means one step before termination. The stakes are significantly higher. Suspension could be paid or unpaid. If unpaid, that has immediate financial and legal implications. The type of action determines your response strategy. A written warning gives you more time and flexibility. A final warning requires immediate and deliberate action. Read the document carefully. Every word. What specific policy did you allegedly violate? What specific behavior or incident is cited? What is the required correction? What is the consequence if the behavior continues? If any of those elements are vague, that vagueness works in your favor. Almost every company has a formal grievance or appeal process. It is usually in your employee handbook or as a standalone HR policy. Most employees never read it. Find it. Read it today. The process typically includes a timeline to submit a formal response. Usually 5 to 10 business days. A designated recipient, typically HR or a senior leader. In some organizations, a review panel. An independent group that reviews disciplinary actions before final warning or termination is issued. That panel is one of the most underutilized employee protections in corporate America. If your company has one, use it. Request that your case be reviewed by the panel. In writing. Before the action becomes final. A grievance is not a complaint. It is a formal business document. Treat it accordingly. Your grievance should include 1. A clear statement of what you are disputing. Not your feelings about it. The specific factual inaccuracies. 2. A timeline of events. Dates. Meetings. Conversations. Every relevant interaction leading to this action. 3. Evidence that contradicts the disciplinary action. Emails. Performance data. Witness accounts. Anything that directly challenges the stated facts. 4. A specific ask. Do not say I want this reversed as an opening. Instead say, I am requesting a formal review of this action, based on the following factual inaccuracies. 5. Any relevant context. Did you recently file a complaint? Request an accommodation. Raise a concern about a manager. If this action followed any protected activity, document that sequence of events clearly. Retaliation claims require documented timelines. If this is a final warning or if the action appears to be discriminatory or retaliatory, I want to be direct with you. Consult an employment attorney before you submit anything. An attorney can review your documentation, assess whether your rights have been violated, and advise you on how to respond in a way that protects your legal position. HR is not your advocate in this process. They are the company's advocate. That is not a criticism, it is a reality. An employment attorney is your advocate. Many offer free initial consultations. Before a final warning becomes a termination, a 1-hour consultation could change your outcome significantly. You received a disciplinary action you believe is wrong. Understand exactly what type of action it is. Read your company's grievance and appeal policy. Write a formal, factual rebuttal. Request a panel review if one exists. Document any protected activity that preceded this action. And consult an employment attorney before the stakes get any higher. Comment grievance below if you're navigating this right now. Disclaimer: this content is based on 20 years of HR experience and is for informational purposes only. I am not a lawyer and this is not legal advice. Every situation is unique. Always consult a qualified employment attorney when formal disciplinary action is involved. This is what the talent. The move is yours.